Welcome and happy February 2024 to everyone down here in the Maritimes. Some of us are digging out, so we're happy that we're getting through the winter, but we're delighted to see you and to spend a few minutes together. Rob, I found this headline really shocking that only 2% of Ontario not-for-profits have filed new articles of amendment with the government, with less than a year to go until the deadline. And uh, maybe this article that reported this is a little dated, but we are just 8 months to go. And is this really a big deal, or is there hope for not-for-profits in Ontario?
Yeah, thanks for setting us up, Dave. And welcome everyone. My name is Rob DeRoy. I'm the Vice President of Governance and Strategy here at Governance Solutions. And I would say the answer to your questions are answers we've given before. Is this a really big deal? Well, the answer to that is it depends. I know we use that line a lot, but in this case, it really does depend on how different your current governing documents differ from what is now acceptable under the new legislation. There are enough differences between the Ontario Not-for-Profit Corporations Act and the Ontario Corporations Act, which you would have been incorporated under previously, that it's virtually guaranteed that there will be differences. That your current letters, patent, and bylaws will have aspects that no longer will comply to the legislation. So I can tell you that there are going to be differences. The extent of those differences, that part depends. But if you have large material variances, then a lack of action could inject significant risk into your organization. And this risk is heightened if you're a charity, if you're a registered charity. Um, be, because if you're out of compliance as a registered charity, you could lose your charitable status. It's possible. It doesn't mean you will, but there are ways that you could. So on the second question, is there hope? I can be a lot more definitive. Yes, of course, there's always hope, and there's hope. We still have 8 months to get our houses in order. You see, the Ontario Not-for-Profit Corporations Act replaced Ontario's Corporations Act for Ontario not-for-profits, and it replaced it on October 19th, 2021. But there was a 3-year grace period. So, and that was to give Ontario not-for-profits time to bring their governing documents into compliance. And 3 years is ample time to review, amend, and get member approval for changes to your articles of incorporation and bylaws. 8 months is still enough time for you to get your not-for-profit into compliance on your terms. And I say on your terms because your not-for-profit will be in compliance whether you act or not. Because if you don't update your nonprofit's bylaws by the end of this 3-year period, it'll just be that the rules that are in your articles or bylaws that are not in compliance will simply no longer be in effect. You'll no longer be able to use them. And if you did use them and someone complained that they didn't meet the legislation, then you would have a problem. So it's not the end of the world, but you'll no longer have the same amount of control over the organization that you had beforehand. So think about that. What if you have classes of membership that have been the cornerstone of how you organize your governance, and they are no longer compliant with ONCA? Just because of the way they're written in your bylaws. If you take control of the changes, you will most likely be able to preserve those things which are most important to you and still comply to this legislation. If you leave it to others, and by others, I mean the government, you may lose important aspects of how you govern your own organization simply through neglect. And if you're a registered charity, the risk is even higher, as I said before. And it could potentially lead to you losing your charitable status. So I wouldn't leave this to others. Dave, do you have anything to add?
Yeah, Rob, thanks for pointing out that time is running out to comply with this new act, but that there is hope. I'd have to say that having worked with several Ontario incorporated not-for-profits, I'm also excited about some of the new features uh, in ONCA that ONCA's brought in. I think you'll talk a little bit about them, but things like having the ability to have a range in the number of directors rather than a fixed number, and even the greater ease of registering a not-for-profit in Ontario is a huge positive change. Rob, what are some of the key things that Ontario not-for-profits need to address in the coming months if they haven't done so already?
Yeah, thanks, Dave. Now 8 months seems like a long time to review some documents and make some changes. But let's run through the process for a second here, just to highlight what is entailed in these changes. The first thing you want to do is understand this new legislation, and especially those areas where it differs from the Ontario Corporations Act. This is a first vital step we're talking about, because we're talking about making changes to our letters patent, to creating articles of incorporation, and doing that in a way that complies with the new legislation. So we have to understand what we can keep, what we can add, what we must change, and other things in our articles. Like, can our purpose stay the same, or is our purpose stated in our current letters patent at all? Can our governance arrangements stay the same, or must they change? Um, and in our articles, for instance, almost all letters patents stated a specific numbers of directors for the corporation. That was how the legislation was written in the Ontario Corporations Act. Now it's a range in ONCA. And it can be a real advantage to have this type of flexibility in board size. So you would want to make that change. There are times when you might want to flex the size of your board. There are times when you may have trouble getting enough directors, and having the ability to still function with a smaller board when you're having difficulty getting directors is a huge advantage that you currently wouldn't have if you haven't looked at those letters patent that you have, because it will have a number on it. So this ability to have a range is a big advantage, and you would want that change to be incorporated in, because it can only help you. Even if you never use it, it gives you a lot of flexibility in governance arrangements that could come in handy, that could really help your organization. So once we understand the differences in this new legislation, and that's just one of them, then we can review those letters patent and review our bylaws with a view to how might we adapt them to comply with this new legislation. But also, how might we adapt them to take advantage of all the opportunities in this new legislation? All the things that this new legislation may afford us, the advantages it may have. And then thirdly, how can we ensure our bylaws still meet the needs of our organization and that they still can be upheld in use? So how can we enshrine those things that are dear to us, that are already there, and still comply to the legislation? So that's sort of that's the next step. Is we could simply just say, what are the few changes we need to make to comply to legislation? Or we could do a more thorough job and use this as an opportunity. And just as a side on changes to bylaws, if you hire legal counsel to help you make these changes, and I suggest you have legal counsel look at changes you make, try to avoid 100% reliance on their services. And by that, I don't mean don't trust that they will create bylaws that are compliant with the new legislation. What I mean is that these bylaws and this purpose in your articles of incorporation need to serve your organization, and they need to function for your organization. We make lots of decisions within bylaws that are meant to help us govern the organization. So the board needs to take ownership of those changes, of those ideas. The board should be involved in determining what is in a bylaw versus what is in policy. I'll give you an example. I see like when we review bylaws, I see lots of bylaws that include the terms of reference for the committees and specify which committees the organization can have. Now, those terms of reference do not have to be in a bylaw, but because they've been placed in that bylaw, and this was really common practice for a long time, but because they're there, if you want to make a change to the terms of reference for a committee or change the committees you have to go back to the membership and get a bylaw revision. So you're really slowing down the machinery of governance as you do governance reviews, as your governance committee reviews changes to legislation, which may require changes to the mandate of committee. You've now created a slower system that you have to go back to your members to make those changes. Whereas if it was in policy, the board could recognize that a change is needed and make the change and move forward. So it's not just whether the bylaws comply, it's also what should be in them and what should not be in them. And it's also how do they enable us to govern the organization effectively going forward and get the outcomes we're looking for. So these are the types of decisions and input that every board should have when these documents are rewritten. So when I say don't do 100% reliance, don't expect to give it to someone else and say, make these compliant with ONCA and we'll approve them when they come back to us. Give input, have a conversation, make sure everyone understands what you want to achieve through bylaw and what you want to achieve through policy and what's important to you within the way you determine membership, member classes, member rights, because all of those are far more enshrined in ONCA than they were in the Ontario Corporations Act. So there's lots to chew over on that. So I would say that, yes, you want to have input. Yes, you want to take the time to get it right. But I also say you have a unique opportunity at this time to update those documents to current best practice. So here's the rub. 8 months is a long time, but you have to get member approval of changes to articles and changes to bylaws. And you have to get those articles in before you file. So you have to get that member approval before you file those changes with government. And we are fast approaching the time of year when AGMs are imminent. If you have a calendar year end, which many organizations do, most organizations do, you're probably already too late or very close to too late to do a thorough job of review or to do alterations to your bylaws. And then to get those things in front of your members for approval in time for an AGM. So that doesn't mean you can't comply to the 8 months, but it does mean that you'll have to call a special meeting of members later in the year in order to get member approval on your new articles and on your changes to your bylaws. So the time to act is today if you haven't already started. Dave, do you have anything to add?
Yeah, thanks, Rob. I really appreciate your wisdom about keeping the bylaws flexible. Just like you, I've seen organizations enshrine in their bylaws committees' terms of reference or even a board charter. And as you said, it makes them much harder to adjust rather than having it in policy. And it's interesting to me that the standard organizational bylaw that you'll get if you don't change your bylaws that the government has put out, that that's how they structured it there as well. They say you can have committees, but define those committees somewhere else. And just a reminder that there are resources that the government of Ontario has for not-for-profits. There are these standard organizational bylaws that you can go and have a look at. I wouldn't accept them just as they are, but they're a good starting point. And then I think I'd also add that if you need to hold a special meeting of members, make sure that you consult your existing bylaws and follow exactly what they say regarding the process and procedures around special meetings. The last thing you want is someone coming back to you and saying, sorry, you didn't comply, and this whole exercise has been futile. So just, yeah, make the bylaws flexible. Make sure that you're saying what resources the government have, and follow the processes and procedures that you have already established.
Yeah, thanks, Dave. Yeah, and so in the government, as Dave has mentioned, there are model bylaws that the government has produced that would comply to this legislation. They are a great resource for you, and I would say they're good bylaws. That just, for the not-for-profits that I've been involved with or I've been on a board on, they wouldn't on their own without some alteration meet the needs of those organizations 100%. It's a framework. It's a insert company name here kind of approach, and they're designed to meet that legislation. So that part's good. But if you wanted any kind of different member classes or any kind of different treatment that would still be allowed, you have to review them, and you have to understand your needs and make those changes and make those bylaws your own. And then just the other note I would add to what Dave said is, yeah, you've got to follow your current bylaws in order to make those changes, unless you're late. If you decide that you can't live with accepting those model bylaws or just the changes that are going to be foisted upon you because you haven't gotten it done, and you're late. If you're past October, then you've got to follow the legislation, because the processes in your current bylaws probably don't meet the current legislation. So timing is important on that as well. Okay, so just a final note. If you fail to make any of these changes, no one is going to come to you or fine you for not getting this job done. There are no bylaw police. However, there are significant risks to inaction, especially for registered charities. For registered charities, the CRA is also involved. And this brings in a different set of rules, or an additional set of rules, and a more stringent oversight mechanism associated with the rights granted to charitable organizations. So even though there are no fines and no bylaw police, the CRA could rescind your charitable status. So if you are a registered charity, then I would absolutely act now, if you haven't acted already, and make sure you get this done. The chance of losing your charitable status over this is probably low, but probably low is probably too high in that case. And for the rest of you who are not charitable organizations, the real risk is that you simply don't get to employ the structures in governance and the rules that you would like to, or the things you would like to have, or the things you've enjoyed in the past, and that could impede future operations. If you're on the board of an Ontario not-for-profit corporation and you haven't had discussions about ONCA compliance, I would strongly urge you to get this added to your very next agenda, and to ensure that all of your board members get up to date on the changes and implications of this piece of legislation, many of which are positive. Change isn't bad, but we want to be, to the extent we can be, in control of our situation when it comes to this change. Dave, do you have anything to add?
Yeah, well, first of all, Rob, this has been super helpful. I think it's a great reminder that we can't just sit back and end up with ONCA imposed articles and bylaws. We really, if we want effective governance in our not-for-profit, we need to be proactive and develop the ONCA compliant bylaws that promote this effective governance. And it's interesting, in this new act, it talks about a duty of care for the organization, duty of loyalty and duty of care that wasn't in the Ontario Corporations Act. So you need to act in the best interests of your not-for-profit. in Ontario. The only other thing I'd add is you've said to be aware of any other acts that might impact your not-for-profit. The Income Tax Act obviously springs to mind, and just make sure you're compliant with all of the legislation that you might be subject to. So yeah, lots of important things to think about.